When we talk about expatriate taxation in India, the concept of tax residency comes into the picture. A foreign national is liable to pay taxes in India based on his or her tax residency during a fiscal year, that is, from April of the first year to the March of the next year. Tax residency is dependent upon the period of stay of the individual in India, and it will determine the scope of income liable to be taxed in India. The residents and ordinary residents are taxed on their global income, whereas non-residents and residents but not ordinary residents are taxed on India-sourced income. The different types of visas issued to a foreign national on entering India are business visa or employment visa, project visa, or a residential permit. A business visa is issued to a foreign national in cases of establishing or exploring the possibility of setup of businesses, conduct trade of goods, monitoring projects, etc. Similarly, an employment visa may be issued for the purpose of taking employment, executing projects or contracts, or providing technical support or services. FRRO registration is mandatory if the individual's stay exceeds 180 days in the calendar year or if there is a special endorsement. An employment visa may be granted to only the following individuals: who are skilled or qualified professionals visiting India for employment in companies in India or in foreign companies, the individuals who are executing projects in India having a salary in excess of $25,000 or 16,25,000 rupees per annum, and similarly, FRRO registration is mandatory within 14 days of arrival in India for these individuals. A permanent account number is needed for any foreign national working in India, and it's recommended for these individuals intending to work in India to apply for PAN at the earliest. There are various modes of tax deduction holding a 0%, 5%, 20% and 30% slabs for expatriate employees, where the taxes can be deposited via withholding tax, advance tax and self-assessment tax. Surcharge is applicable at 10% if the income exceeds INR 50 lakh and 15% if it exceeds INR 1 crore. Education cess is applicable at 4% across all cases. India has entered into 94 DTAAs, which are double taxation avoidance agreements, and 10 tax information exchange agreements. A foreign national can avail DTAA benefits by providing a tax residency certificate to the Indian authorities. Talking of social security obligations in India, a foreign national working on an employment visa in India for an establishment to which Provident Fund applies shall be liable to contribute to India's social security. However, there exist provisions such as the social security agreements which permit him to not contribute to the social security in India. An individual returning to his home country from India must obtain an ITCC, that is, a no objection certificate from Indian tax authorities. It shall be presented to the immigration authorities at the time of departure from India for the individual. For more information on the topics covered in the video, download our exclusive PDF file from the link in the description.